The prolonged delay by the Constitutional Court on petitions with serious ramifications for the rule of law, fundamental rights, and freedoms in Turkey has raised fears of political influence of the Justice and Development Party, AK Party, in the judicial system. There are various controversial laws introduced by the AK Party government that have been criticized as arbitrary and abusive in the last few years. However, the top court has not yet rendered verdicts regarding numerous petitions filed mostly by the main opposition Republican People's Party, CHP, against various pieces of AK Party legislation. People's Democratic Party, HDP, CO Chairman Ertuğrul Kürkçü, speaking to today's Zaman, said the Constitutional Court has turned into an institution under the influence of the AK Party government due to the direct intervention of President Recep Tayyip Erdoğan. It is a basic principle that delayed justice is not just. What is the Constitutional Court waiting for to annul this law on closing down Dershanes University preparatory schools, which is clearly against the Constitution as it blocks private enterprise? This can only be explained by the fact that the top court is operating under the influence and orders of the AK Party, Kürkçü emphasized. The AK Party government's bill banning the privately owned university preparatory courses was passed by Parliament on March 7, 2014 and signed into law by then-President Abdullah Gül 5 days later. Under this law, all Dershanes will be shut down by September 1 of this year. The CHP challenged the law last year, saying it was a blow to the right to free enterprise. The top court's rapporteur has finalized a report on the issue, yet the court has not yet tackled the case and the legislation has been pending before the court since then. Pointing to legislation passed in April 2014 related to the National Intelligence Organization, MT, that gave the agency sweeping powers to conduct surveillance and monitor unsuspecting citizens, Kürkçü also asked why the top court is waiting to annul the law which wants to turn Turkey into an intelligence state just like the Assad regime in Syria. The MT law was challenged by the main opposition CHP in April of last year. In addition to the CHP, many owners of prep schools also applied to the Constitutional Court against the law, claiming their fundamental rights were being violated. Kürkçü also added that the top court's delay in responding to a number of petitions filed against the MT law and the other controversial laws introduced by the AK Party cannot be explained by the busy schedule of the top court, but with the political influence on the Constitutional Court. CHP Konya deputy and former member of the Parliamentary Constitutional Reconciliation Commission, Attila Kart, told today's Zaman that the Constitutional Court operates according to the political atmosphere and added that the top court has strayed from its real purpose. Saying that the long delays in the judicial process decrease the effect of the decisions, Kart reminded that the deadline for the closure of the Dershanes is September 1, adding, "It will be completely unnecessary, if you give your decision on the law concerning the Dershanes 3 months later." The petition, which concerns millions of people including the Dershane employers, teachers, students, and their parents, will become pointless 3 months later when the deadline passes. A new era has started. The Dershanes face closure, serious right abuses have emerged, but you the top court won't give your decision. If you cannot decide over violations of fundamental rights such as private enterprise and the right to own property, you have shirked your duty. Saying that the judiciary, politics, and media are controlled by the government through MT, Kart said the Constitutional Court again has failed in fulfilling its mission by delaying the annulment of the MT law, which paves the way for human rights abuses and other unlawful practices. The CHP has repeatedly said the government is using the intelligence agency to illegally monitor opposition parties and lawmakers with flagrant interference in their private lives. Speaking to today's Zaman, Felicity Party, SP, leader Mustafa Kemalak said, "The delay in justice is no different from the delay of medication for a sick person." Kemalak has called on the top court to break from political influence and give its verdict regarding these controversial laws as soon as possible. Jurist points to 3 scenarios over top court's delay. Brahim Kabolu, a professor of constitutional law at Marmara University, told today's Zaman that there are 3 possible scenarios that explain why the top court has yet to give a decision on petitions filed against critical laws such as the MT law, the internal security law and the law concerning the closure of dörfhains. The internal security law allows authorities to arrest suspects based on reasonable suspicion instead of tangible evidence. With this law, the threshold for the burden of proof that is required for obtaining a search warrant was reduced from concrete evidence to mere reasonable suspicion. Under this law, the police are not only able to easily search any individual, their home and vehicle, but also easily seize the property of all so-called dissidents on suspicion that they committed a crime against the government. Cabolo said the first reason might be the heavy workload of the Constitutional Court, adding that the top court has to deal with both individual applications from citizens and petitions filed against legislation. In this context, Meet Göktürk, a former chief prosecutor of the now-dissolved State Security Court, DGM, agrees with Cabolo by saying that the individual applications that the top court began to accept in September 2012 have paralyzed it. Göktürk told today's Zaman that court is now too busy because of the volume of individual petitions. Cabolo said the second reason might be the recent decision of the top court to declare both its verdict and reasons at the same time. Recalling that the top court used to first declare its verdict and later announce its reasons for giving the verdict, Cabolo said the Constitutional Court might have already given its verdict, but it might be waiting now for the reasoned decisions before making an announcement. Cabolo said the top court might have waited for the June 7 parliamentary election before giving its verdict on those laws put in place by the AK party, suggesting that the court might be under the influence of the ruling party. Declaring that the top court should have already announced its verdict, Cabolo pointed to the critical significance of the annulment of the internal security law due to the serious abuses of human rights that it allows. Cabolo was personally involved in the preparation of a report from the Association of Constitutional Law Research to expose the unconstitutional components of the internal security law. He said the report was sent to Constitutional Court President Suto Arslan to urge them to annul the law on May 25.